All right, we're live. We're here with Frank Herrera with the FDA Update. What's going on, Frank?
Hi, how are you?
I'm doing well. I'm doing well. We got everything up and running finally, and that's always a challenge. So
No, go ahead, please.
great. Okay. Once. Okay. I had us running in the background, which was fun and echoey. Okay, so let's go. So there's been some things that have happened, some significant court episodes, some decisions made, and I was wondering if you could give us the update on what's been decided. What does it mean?
Sure. So, as you and your listeners or readers, right now, your watchers, all know, there have been several cases filed against the FDA by various organizations and companies. Of course, everyone knows about CRA, IPCPR, CAA filing. We'll talk about that one in a minute, but there's really not much to talk about that case because it's kind of in the early stages. But there was a case that was not really made too public, I guess, and folks haven't talked about much. But it's a court case against the FDA at the United States District Court for the District of Columbia, and that was brought by Philip Morris against FDA. And recently, as of August 16th, the judge in that case issued an order that is pretty significant and is actually very beneficial for the cigar industry, namely cigar manufacturers. And it's about a 43, not about, it is a 43-page opinion, and I'll do my best to kind of just break down, what it's all about. So Philip Morris brought an action and against the FDA and essentially said that some of the guidance documents, not these deeming regulations we're all very familiar with, but the guidance documents specifically about substantial equivalence, they said that there were some problems, to speak like a layperson, and it was sync intended in the Tobacco Control Act. And primarily, they just to break it down, there were two issues presented to the court, and that the court decided. And I'm just going to read exactly what the court says. It says first, these are the questions presented. Does a modification of an existing product's label that renders the product label distinct from its predecessor create a new tobacco product, such that the newly labeled tobacco product is subject to FDA approval through the substantial equivalence review pathway? And what does that mean? Okay, so in the past couple of months, my phone has, and I'm sure other folks who deal with this, has not stopped ringing, and our clients are asking us specific questions about what products must go through the specific pathway known as substantial equivalence reporting. Okay, as we know, there's grandfather, there's substantial equivalence reporting, there's exemption, and then there's kind of an expedited substantial equivalence.
Yes.
So folks say, as you know, they go, well, I had this product and it was grandfathered, but then I changed the packaging. Does that new packaging product that came after February 15, 2007, do I have to do a substantial equivalence report on that? And I told them, as I think most people would say and read the rules as they were, would say yes, because it was new packaging, and pursuant to the FDA's guidance documents, any change in the packaging that is beyond a slight variation would constitute a new tobacco product subject to a new application. So they start doing the math, and they're like, wow, well, we've changed packaging on this, and we did this, but it's all the same product. And I said, I'm sorry, that is really how we read the regs. So that's the first question that was presented. The second one was, does a change in the quantity of an existing product create a new tobacco product? Therefore, have to have a new substantial equivalence reporting. So say you had a product and you came out with a 10-count box, and then subsequently you came out with a 20-count box. Those would be different tobacco products, and each of those would have to go through a particular pathway, whether it was grandfathered or substantial equivalence report or what have you. So those are the two questions. And Judge Mehta, Mehta, answered the first question and said that a change in a product does not necessarily constitute a new tobacco product, because Congress never said that labeling, essentially, changes in labeling, would constitute a new product. So what does that mean? This judge understands, in my opinion, that just because you update your product packaging and marketing materials, the product itself, it doesn't change the product itself, the actual cigar, the blend, whatever else. Now, that might change it if there's tweaks and changes to the product itself, but mere packaging changes do not constitute a new product. Why is that significant? It's significant because whereas a manufacturer would have to register every single one of these variations if it wants to keep the product on the market, past the grace period. Now, at least pursuant to this opinion now, they would not have to. It gets more complicated than that, but generally speaking, it's a very good thing for the cigar industry. We still have FDA, regulation. We still have a lot of other things, but this is significant. It hurts my pocket, of course, and any other lawyer or anyone else does this, because we would be doing fewer filings on this. But I think it's better, and I think it's better for my clients, our clients, that they don't have to bankrupt their company just to comply with what the FDA thought was a new tobacco product. Period. So now let me tell you, that's not the gospel according to Judge Mehta or the FDA right now. There was an order, as I just mentioned, August 16th, but that judge remanded that back to the FDA. Essentially what they said was, FDA, your guidance document that you initially came out with in 2011 and then updated in 2015 is not right. You misunderstood Congress, and now you have to go back and update that guidance document. So the FDA now has opportunity to go back, take what the judge said, and reevaluate this. Now, it could be that the FDA finds a way to do exactly what they said they were doing, essentially, right? But in my opinion, I don't know what's going to happen. If I was the FDA, I think this opinion is pretty well considered and reasoned. I think I would provide a new guidance document that says exactly what this judge says on that point.
Is there an opportunity with this reevaluation of this guidance document that new things could be added that aren't necessarily related or only tangentially related, that would kind of alter our current understanding of what's the regulations are?
Well, you broke up a little bit there, but I think I caught what you said. I think anything is possible with the FDA. I'm sure that they are not pleased with the outcome of this, but they now have direction from a federal judge, a very well-respected federal judge in DC, that they need to do their homework and not just think that they're going to come out with something and slide it through. They need to find statutory authority for what they say, and not, come out with something that they think they read, if you follow me.
Yes.
Yeah, the second question in this case was about whether the quantity change constitutes a new tobacco product. And the judge says it does. The judge says that if you had a 10-pack and now you had a 20-pack, or et cetera, it is a new tobacco product subject to a pathway. So if you had a grandfather product that was 10 count, and then after February 15, 2007, you came out with a 20 count, but everything else was equal, the product was the same, the packaging was the same, whatever, that new count would be subject to a substantial equivalence report if you want to keep it in the market past the grace period. Now, a lot of people have read said, oh, how can you go this way and not the other? And I disagree with the court. I think I don't think there's that a quantity change presents a new tobacco product, but I understand the reasoning. And the reasoning, I believe, is based upon cigarettes and not cigars. So if you can imagine a tobacco product that has a 10 count, say it's cigarettes, but now there's a 20 count, then it is possible that if you had a 20 count box of cigarettes, you might smoke 20 in a day, whereas a 10 count, you might only smoke 10. So it might present a new question of public health. I think that's the reasoning. But for cigars, either you smoke 8 cigars a day, or you don't, or you smoke 1 cigar a day. Or I think, as you and I have been around this a long time, I think the court and FDA and a lot of people misunderstand the use patterns of cigars. It's not a gateway drug. It's not a, teenagers don't want it. I mean, I have cigars all around my house and teenagers and their friends, and I've never once had a single cigar go missing. They don't want them. Now, liquor and beer, I mean, that's a different issue,
Yes.
Teenagers simply don't want these products. So I think the court decided that the FDA's guidance on quantity change as it relates to whether it's a new tobacco product, they said that was fine. So end of story here. The short of it is a very well-known district judge in District of Columbia issued an opinion that is significant as long as the FDA actually takes direction from the district judge and reissues a guidance document that is in line with what that district judge said. Now, there's one thing I want to mention about that. We are now August 29th, and so we're 21 days, 3 weeks into the deeming regulations. So what the court did not address is the fact that time has passed, and time will further pass until the FDA reissues that guidance document. It may be tomorrow, it may be 6 months from now. Unfortunately, the cigar industry does not have guidance right now as to really what's going to be the new normal. So in our case, which I'll talk about in a moment, I think we're going to amend our complaint and ask the court if they could stay the effectiveness, if you will, of the deeming regulations until such time as we have a final ruling or a final understanding of what this means. To break it down for you, why should we sit around and wait to find out what the FDA means? Because we have an 18-month time clock. Remember, if you're going to do a substantial equivalence report, you have to do it by February 8th, 2018. So we're sitting around saying, what does it all mean? Us, our clients, everybody else. And until such time as we have a definitive answer, we don't want that time that's lost where the FDA is figuring it out to go against us. Very specific point, clients come to me. There are a couple different types of clients. One is, let's do it all right now because I just want it off my, my books or, my mind. Let's file all these reports right now. And then I have others that say, oh, we'll wait till the last minute. We can't do either. We can't do either. We can't do them right now because in good faith, I cannot take a client's money, create a substantial equivalence report with the possibility that the FDA may still change its mind or this may still further develop. Alternatively, we can't wait till the last minute because we're at the last minute. If the FDA doesn't agree with our report, we won't have enough time to file follow-up reconsideration letters, that type of thing. So we're losing time. We're already almost a month in. Now we're 17 months to our deadline. In our case, I think we're going to go to the court and say, please, either issue a stay of effectiveness or grant additional time or send it back to the FDA to give us additional time, whatever the statutory authority governs. Okay, so that's the Philip Morris case. I don't know if you guys could see this. No, probably not.
Yeah, it looks pretty clear.
Okay, and so the case number is there if anybody wants to look it up and start following it. I don't know if folks have access to Pacer or not. So there's a couple other cases against the FDA. And this is not definitive. This is what we know of at the moment. There's a case called Lost Art Liquids. This is actually a vaping case. Vaping, whatever you call it, I guess. It could show how ignorant I am to that industry.
Vapistry?
Yeah. But this is called Lost Arts Liquids against FDA. This is actually filed in California. They're out of California. It was filed May 19th. It hasn't really gone anywhere yet. This case is just in the early stages. They have recently filed their proof of service, or thought they filed their proof of service on the defendants. So there's really nothing substantive going on in this case right now. Okay. Now the interesting case that's going on is NicoPure Labs versus the FDA. This is the Pacer printout of the docket. This case started out, or still is, in the District of Columbia, which is the same court we have of the previous case but before a different judge. This is before Judge Amy Berman Jackson, the Honorable Judge Amy Berman Jackson. And so Nicopure filed against the FDA 5/10, so the date of publication of the deeming regs, not of the effectiveness, but the date of. And then what happened was another group filed in the same court, and the court actually consolidated the cases for judicial economy. So it said, okay, we hear you, Nicopure, we hear you guys. You're basically saying the same thing. Let's combine the cases. You can still argue separately what you want to argue, but we're going to have this on summary judgment. So this has Nicopure, these are plaintiffs, Right to Be Smoke-Free Coalition, American E-Liquid Manufacturing Standards, American Vaping Association, Electronic Vaping Coalition, et cetera, and then a lot of state associations, Kentucky, Georgia, Louisiana, Maryland, Ohio, Tennessee, on and on and on. So this case is actually moving along, and recently the plaintiffs filed for summary judgment, and I believe that the defendant, FDA, has filed some opposition briefs. So, and in fact, the reply as of today, the 29th, the plaintiff filed a reply. So the next step in that case is going to be probably a hearing, and then we'll get an order from that case. And that case is different from our cigar cases because what they're saying essentially, and don't quote me on this, is that they're vaping. They don't always have tobacco in their products, and to the extent that the products don't have tobacco, they should not be regulated by the FDA. And I think they have pretty good arguments.
Not only that, but in some cases, no tobacco and not even any nicotine. It's all like flavor.
Yes, that's what I meant to say. I'm sorry, and nicotine, right? And that's a big argument. The other thing, they do talk about the predicate date, which I think is pretty significant for us. So that's part and parcel, and I'll talk about our case in a minute, why we've kind of held back a little bit, because we want to see what's going on up there before we kind of go full on our case. So I haven't pulled up their the opposition briefs, but the Nicopure folks, the plaintiffs, they're doing a really good job. They have best counsel out there. So we should hear and see an order from that court in the next month or so. It all depends. Court can have a hearing and then issue the order tomorrow or whatever. So we don't know, but it's fully briefed, and it's not fully briefed. It's very close to being fully briefed. So that's the Nicopure case in the District of Columbia. And then there's the Cigar Association of America, CAA, Cigar Rights of America, and IPCPR that's in the District Court of the District of Columbia as well, which is also the previous two cases we talked about. They filed in July 15th, a little bit for the IPCPR. They have recently issued or have a return of service on the defendants, and it's at the initial stages. So there's no summary judgment pending. There's nothing else. I'm not a part of this case. I don't know what else might be going on. But if I were a part of that case, I would guess that they're also waiting to see what pans out in these other cases, because they're a little bit before them, and what those judges rule upon may be, have some guidance on there. In fact, now that I look at it, Judge Mehta is actually the same judge on the Cigar Rights of America case. So that's a pretty good draw. I'm not sure if that's, yeah. It just occurred to me. So I think that bodes very well for the IPCPR, for CRA, for CAA, and they're probably waiting to see what comes back from the FDA on remand to kind of push that case along. They do have different issues that they brought up from the Philip Morris case, but I think they got they have a judge that's well versed in this and already knows that the FDA has kind of fudged a little bit on some of these issues, and so that's a pretty good draw as far as a judge for them. And of course, we have our case, which we filed on behalf of Global Premium Cigars, which is better known as 1502 Cigars, owned by Enrique Sanchez. We filed that in the United States District Court for the Southern District of Florida in Miami, and we're at the early stages. We did get service of process on the FDA, so procedurally we're at kind of the same situation as the IPCPR CRA case, early stages filed, waiting for the other side to answer. The next step will be for FDA to file an answer or a motion to dismiss. Most likely to be a motion to dismiss. We don't know. And then once we have that, we will move for summary judgment as is required in these cases. And essentially, but before we get that, back up for a second, we are going to file an amended complaint, and we're going to add a couple more causes. I don't want to make them public just yet, but one I already mentioned about maybe seeing if we can stay the effectiveness of the deeming regulations. And then we have a couple other causes of action that I think clean up some of the questions we didn't present initially. So that's your FDA litigation update. Some of it's for vaping, some of it's cigars. It's not comprehensive. There may be other cases out there, but those are the ones that we're tracking right now.
They're still figuring things out. So I had one question, and hopefully my signal's coming through strong.
Yep.
Why, with the substantial equivalence, could not every cigar manufacturer out there simply file for all their cigars on the basis of them being products that contain black tobacco?
Yeah, well, that's what the problem lies in, that the FDA does not understand this industry, right? So this all came about because of cigarettes and everything else. And unlike cigarettes, we are just tobacco and water and maybe a little vegetable glue. Really, that's pretty much it. The FDA doesn't really understand that. So it's going to be our job as counsel to educate the FDA that these products really are as natural and as simple as they are. And in such case, there's no difference. Well, the products are actually substantially equivalent to each other.
Yes.
I mean, there are exceptions. There are some cigar makers that do add some goofiness to their products. We've all heard stories of there being additives, that type of thing. And in time they go out of business, or they'll be subject to regulations and they'll have to show their cards. But most law-abiding cigar manufacturers are creating natural products that are substantially equivalent to their predecessors. Really. So the FDA needs to go back and really understand this industry, and hopefully they'll do it in a way that does not decimate the industry, because it truly is an industry that in large part is handcrafted, natural, and really has the ingredients that of, that we tell you that's in it. Regulation is okay. I think regulation, we can deal with it, we can handle it, but we need to be regulated by a group or an agency that understands what they're doing. My office and an associate works for me, and my paralegal, we have, I don't know how many times we've called the FDA in the past 2 or 3 months, and they're a disaster. There's one guy there, and I won't tell you his name because he's our kind of in right now, that's actually responsive and giving us more than just kind of a BS response. But emails to them are answered with ridiculous responses that are non-responsive and just provide links to a non-responsive web page. Calls, except for our guy, are in large part ignored or responded to days and weeks later. The guidance online is terrible, and even tech support for the programs that we use, to start preparing things is terrible. So, if you're going to do something this significant to regulate an industry, at least have the tools and the intelligence to help us in this process. I mean, we're not asking you, I'm talking to the FDA now, obviously, to just make everything 100% easy, but at least pretend like there's an industry here that needs guidance and that needs to know what's ahead of it, because we can't plan without any guidance. All right.
That seems fair. It seems fair. I wonder how many people are going to go out and actually try that, though, and say, hey, this is all black tobacco. That's it. It's identical to everything else out there.
Yeah, I can tell you that the bigger companies are being told that by their counsel. I've been in meetings where other counsel has been present, talking to CRA, and they're telling them to be very, very basic. And I don't 100% disagree with that, but I also think that you have to have a level of credibility with the FDA when you're communicating with them. So remember, we think, hey, just tell them whatever you want. But remember, on the other side of the computer is someone who is equally savvy at researching and finding information. So if I simply put black tobacco in a substantial equivalence report, I cannot tell a client with any confidence that the FDA will not come back and ask me for more information, in which case, country of origin, whatever the case may be. But right now, it's our duty and our obligation to at least put some identifying information in these applications so that the FDA has an understanding of what's in the product, right? Now, we don't know to what degree the FDA is going to dig down. We don't think it's necessary for them to ask for varietal or country of origin or region, rather. But we also don't want to pretend like we're going to put one over on the FDA, by just being so generic. I think that's a waste of everyone's time. But again, the only time will tell what the FDA will accept and not accept. And anyone that tells you that they know the answer to 100% certainty right now is lying to you, or they're just ignorant, or they're both.
Yeah, so I guess I could see them being savvy to somebody trying to pull the wool over their eyes, or the feeling that somebody is. So
Yeah.
that might, being super general would backfire probably.
Yeah. So, the FDA is going to get a lot of filings. They're going to get a lot of filings from big firms, from very sophisticated manufacturers, and from small firms. And they're also going to get a lot of filings from little tiny manufacturers who are trying to save a buck. And those filings may contain information that might shoot the manufacturer in the foot, whether through ignorance or gravitas or whatever the word is, that they think they're going to put one over on the FDA. I mean, I just caution people, they're not your friend. You don't have to be combative with them, but the FDA wants this industry gone, 100%. It is in there. That's what they want. So be very careful what you tell them. You can't lie to them. You can't, misguide them or to anything. But be very, very careful on how you communicate with them. Sorry about that.
Phone's ringing off the hook.
Yeah.
So with the changes to packaging, that ruling, does that free up both manufacturers and retail to make desired changes to packaging like extra bands or whatever, that sort of thing, or it's still up in the air because the FDA has to officially decide on it?
Right. Well, so best case scenario is that judge's ruling is the new normal, right? So if we make a packaging change today, that new packaging change pursuant to this court ruling would not be subject to a new PMTA. It wouldn't be a new tobacco product. But remember, the predicate product, or the one that wasn't changed, the one that came before, that would still need to go through a PMTA or be grandfathered, right? So just because you have so for instance, you had a grandfathered product and then you changed it. Well, you can register your grandfathered product, and then the new one you won't have to. But remember, you have other obligations to the FDA. You have a product listing that you have to do before the end of this year, along with your establishment registration. You have to update the FDA on your products. If you add products, drop products, change products, you have a continuing obligation to do that throughout the years. And so, my concern is that this new judicial order, sorry, something just came in. This new judicial order, people are reading and say, that's the new normal. It's like, well, no, there's a lot of other things that can happen. And you have to, every single case, every single client, every single instance has to be evaluated. You can't just have the new law and that's it applies. No, we have to look at it in context and say, okay, well, yeah, it is new packaging. That's fine, but X, Y, Z. Sorry, man. I don't know why I have this phone in here. I'm not even sure if I answered your question now.
No, I think so. I think so. I was partially forgetting that all of that had to go back to the FDA for them to revise it and then instruct us or figure out a way to get what they wanted in the first place anyway. So it's hard to say.
Well, the interesting part of the order, and of course I don't have it queued up right now, but the judge said, if you look at the Tobacco Control Act, they do mention this, they do mention that, and they mention whatever it was, label or something, 100 and something times in this section. But they said when it came to a new tobacco product, they never mentioned that. They never mentioned labeling. So it's obvious from the statute that a change, Congress did not intend every change to packaging to be a new tobacco product subject to a new PMTA pathway. So again, I'm not
It
sure.
does make sense. No, it makes sense. And you've answered me as well as you can with what the FDA has given us to work with, I guess, right?
Well, that's what we have right now. I mean, if you go into the FDA's website and they show you their guidance documents, they haven't. I don't think they've even taken down the guidance document that is subject to this order. It was the September 2015 guidance document, I think, on substantial equivalence. I think it's still up there. There's no asterisk on it that says, "Oh, we had a federal judge says this is BS." So they're pretty slow. They updated a couple other guidance documents a couple weeks ago, but there's just I don't know. I don't work for them. I can't, I don't know them, but I think they're under a lot of political pressure to get things out, and there's a lot of groupthink going on, and no one's really saying, hey, there's a whole industry out here whose livelihood, is hanging on the balance of what we say and do, and time is ticking, and clients calling us and asking for some specific answers. They're all good questions, but unfortunately, we can't give them a definitive answer. So this court ruling, I think, is significant. We've notified a lot of our clients, if not all, about it, but we told them, just hang on. Let's see how it pans out. Let's see what the FDA says. Let's see if the FDA appeals it, which is probably not likely, but it's possible. Let's just see what happens in the next couple months.
Great. Well, thanks for taking some time to talk to us. I think we've covered pretty well, thoroughly covered what's the newest developments have been in the FDA case. So I really appreciate it.
I appreciate your time, and as always, if you need anything, just let me know.
Yeah, tell them. Go ahead and give them your contact information.
So it's many different ways you can find me. So the firm is hnewmedia.com. That's the law firm, and Cigar Law on Twitter, Frank Herrera on Facebook. Whatever, just find us if you need us. We don't charge for initial consultations, and I appreciate the time here. Thanks.
Thanks a lot, Franks.
Take care.
Bye.
Bye.